Another one of the main triggers in discovering unreported foreign assets is the death of a spouse or the death of a parent. When someone dies with foreign assets in their estate, the executor or the trustee of the trust needs to assemble an inventory of those assets. When assets have been disclosed, then the issue comes down to whether or not they are properly valued for estate and gift tax purposes, and whether the title clearing process in the country where they're located has been complied with. Where they have not been disclosed, then it is incumbent upon the trustee or executor of the estate to separately go about making sure that those deficiencies are cured. Their role is to act as a fiduciary for the benefit of all of the heirs and beneficiaries of the estate. In taking that role, they have an obligation to minimize the penalty exposure for unreported and undeclared assets. The executor can even go so far as to file a voluntary disclosure for the benefit of the estate and disclose the fact that the decedent had offshore accounts or offshore assets that were not reported, and take advantage of the voluntary disclosure rules to minimize penalties and preserve the estate as much as possible. Those beneficiaries are responsible for the penalties that are assessable on the receipt of those assets, and in the case of gifts, responsible for the gift tax. Well, acting without help probably exposes them to penalties that they don't wish to be personally exposed to. So it's a matter of a judgment call. Hire somebody competent now, or run the risk of paying for it down the road and still having to hire somebody competent.